would the paid members of the class have any objection if for this month we allowed all the classes to be open so that we can go through what we're going to start with tonight and conclude the end class of the month with a run through of the cross-examination that Jane's going to have to do in court. I've been working on a script for her for the last 2 days that goes through everything, and I want to show you how that script is designed and organized.
I got my questions, my cross-examination.
Well, good. You've got your questions. Let's compare them to the ones that I've done so far and see how you doing.
All right.
Okay? Can everybody see what's on the screen?
You won't believe how good mine are. But anyway, go ahead.
Well, again, we'll find out at the end of this.
All right.
Cross-examination instructions. Now, I recommend that when you do your instructions, when you start one of these, that you put at the top of every page as part of the title which cross-examination sheet you're dealing with so you can keep track of them, because you're going to have a separate one for every case you handle when you go to court. They're all going to be organized the same way, but you don't want to be changing one that you need for next week for a case you've got tomorrow. And if you're waiting until the day before to do this shit, you're already screwed. So think that one over too.
Yeah.
All right. If you learn anything about cross-examination, learn these things. 1, cross-examination has 4 primary objectives. Disprove or nullify opposing counsel's facts to the greatest extent possible to disprove their case. Get your own opposing facts into the record to win your case. Discredit or nullify opposing counsel's witnesses and evidence to the greatest extent possible in the eyes of the judge and or jury. And do all of the above without looking like a lost, cocky, or overly aggressive and or desperate asshole. More flies with honey and all that shit. 2, unless you are Jerry Spence, one of, if not the greatest defense attorney or criminal defense and civil attorneys to ever enter a courtroom, he's never lost a criminal case in well over 50 years, then without exception, your cross-examination questions should always be formulated as leading questions. 3, a leading question is formulated as a question that has only one possible answer out of a yes, no, or true, false. For example, officer, isn't it true that you never personally witnessed a defendant driving a car? Isn't it also true that you never had the defendant perform any field sobriety test before you placed them in cuffs and arrested them? Isn't it true that you never offered the defendant an opportunity to perform a breathalyzer test? Isn't it also true that you never obtained a warrant to get a medical blood draw from the defendant? Those are all leading questions that only have one of 2 possible answers: yes or no, true or false. You got it?
Don't mean I'm okay. I'm just standing here back here looking.
Yeah.
Well, who is that? Who's saying that? Is that
A little bit of cold going on here.
Tim? Would you mind muting your mic? In a criminal case, neither party can ask leading questions of their own witness. Okay, does everybody know what your own witness is?
Witnesses you call.
No. Your own witness is the witness of the party who first called the witness to the stand.
Yeah.
First called, not called, first called.
So for my example would have been the cop, correct?
No, because the prosecutor is the one who first called the cop, unless they let you go first.
Okay.
Okay, that's why they cannot ask leading questions of the cop, but you can. He's not your witness. And if they waive their right to go first and you have to go first, then you call the cop to the stand. And the first thing you do is look at the judge and say, Judge, I would like to declare this witness as hostile.
What is the rationale behind that?
He's the opposition's witness against you.
Okay, I see what you mean.
So since he's against you, there's nothing he can be but hostile, right? Because he's trying to offer evidence to convict you.
I see what you're saying.
They don't have to be hostile because they're willing to smack you in the head with a stick or shoot you. They're hostile because they're the one offering the testimony that can convict you. Everybody clear on what a hostile witness is?
Yes.
Unless the calling party first asks the judge to declare the witness as hostile and the judge allows it. 5, conduct your cross-examination in an organized and logical manner. It makes your points easier to follow and consider. You do this by A, starting from any useful foundations created by the prosecution during their direct examination. B, build on an existing foundation or create your own by using each question to lay foundation for the next question, like a set of stair steps or rungs in a ladder. C, stay on point with your questioning. Don't run off chasing alternative facts and tangents that may be provided by a witness, Jane. And don't fumble, ramble, or look lost. D, if unexpected but useful alternative facts or tangents are provided by a witness during cross-examination, make a note, and that should be during direct or cross-examination, because they can offer useful things in their testimony during direct examination too. Hopefully you've been thoughtful enough to address them before they ever got up there to testify. But in case they surprise you with something new or unexpected, make a note of it as part of what you're going to ask during your cross. But don't let it sidetrack you from the other stuff you've already got planned to ask that you must ask. Okay?
All right.
Make a note and then plan for questioning the witness after you have completed your pre-planned questioning, unless waiting to follow through on those facts or tangents would be detrimental to your case in some way if not addressed immediately. Now, in case you're wondering, this can happen on direct in only one way, and that's if the witness testifies to something that requires a legal conclusion in order to make that testimony, such as a definition or a statement containing a statutory term that has a legal definition. Okay? Because then you want to object and say, objection. I wish to voir dire this witness as to personal knowledge of that statement. Okay? That's how you bring this to bear in a direct examination. Otherwise, you make your note and you follow up during your cross. Okay?
Yeah.
6, never formulate your leading question as a self-contradicting question. For example, officer, is it or isn't or is it not true that? Can anyone not understand how is it or isn't it cancel each other out?
Yes.
Yeah.
Same thing with officer, did you or didn't you? Those cancel each other out, do they not?
Yeah.
So
it's just better
don't formulate your questions this way.
Yeah.
Number 7, listen to what you hear. And no, they are not the same thing. Listening equates to analyzing, but you can hear many things during trial that don't necessarily have any real value to your defense and should be ignored, while simultaneously hearing things that are and could be very relevant or potentially useful and should be analyzed for potential value. Listening is how you tell the difference. Be aware, useful facts and information may not always come directly from the witness currently testifying on the stand. Discussions or whispering going on around you during trial may also prove relevant or otherwise useful from time to time, especially when you're pro se and there are other attorneys sitting in, observing, and commenting amongst themselves about the proceedings. But don't lose focus on what's most important. the witness testimony, and the questions being asked by opposing counsel. Now, what's important about listening to what's being asked by opposing counsel?
And to make sure you ask questions related to that, to deny it or to disprove it.
No, that would be the answers that are being given in response, would it not?
But also too, what to object to.
Yeah.
Correct. God damn it. Why does this freaking thing do this just out of the fucking blue? Eight, you must always be listening to the questions being asked by opposing counsel so you know when and what to object to.
Is this something in our public folder? Because I think I've seen something similar somewhere else, but I'm not sure.
As far as what?
What you're working on right now on the screen.
No, there's a script, cross-examination script for traffic cases. It's not nearly as extensive as what I've done here because I had to write that one on the fly for somebody that had court the next day as well. Because they waited right up till the day before and then call me or email me, I should say.
Yeah.
At 5:30 in the freaking evening. I got to be at court at 9 a.m. and I don't know what I'm supposed to be asking.
No, I get it.
And ladies and gentlemen, I hate to sound the way I do, but from this point forward, all I'm going to say when that happens is, well, ain't that tough shit?
Yeah, you're SOL.
Because
Well,
I'm not going to stop everything in my life to fix a problem you created by waiting so damn long.
Well, I don't have my court date anytime real soon, hopefully.
Well, I'll have mine scheduled on the 28th.
Okay. Well, Jane, you make damn sure you save those letters that are labeled as pre-warrant notices. So that's going to come in real handy at the lawsuit for malicious prosecution.
All right.
Because the purpose of those letters is to intimidate a person to pay the fine without adjudicating it, even when they haven't had their day in court.
Well, they sent me those warrant notices that were unpostmarked from that first court whenever I had that, well, wherever that traffic warrant came out of from Beaumont. They were sending it from a third party. I kept all of those notices.
Well, the third party was the
other law firms that were
the
creditors.
collection law firms. They weren't
they
the
were creditors.
Yeah.
Yeah, I kept them all. And they're all.
But see, the ones that Jane has actually has a municipal court seal on it. They're not signed by anybody, but they have the Irving Municipal Court seal on them.
Oh, mine weren't even from a court. They were from a third party.
But hers actually has a seal on it that says they are.
Oh, that fucked them over big time.
Oh, yeah. They're royally screwed.
Well, they in that violation history report I sent you, it shows on there who generated those. And that was a judge's secretary, it looks like.
Well, her ass is grass too.
Yep. Yep. All of them are. Well, I'm not suing her. I'm suing the prosecutor, I thought.
You're going to get to sue everybody because the judge has no immunity if they're acting without jurisdiction either.
Okay.
All right. And last but not least, make your objections timely, which is why listening is so important. All right. Now that said, let's get into the cross-examination checklist of actual questions. Now, like I say, you should know what questions you have to ask if you've read the statute or ordinance you're being charged under. If you read it, if you read everything, then you should already know what they have to prove. They have to prove every single one of the elements of the offense that is written in that ordinance or statute, and some that may not be written in that ordinance or statute. Like in the case of speeding, there's nothing in the statute that says that they have to put in the complaint or get testimony as to what the posted speed limit is and what the actual traveled speed was. But they can't prove the element of speeding unless those two facts are asserted and proven in the case, right? There's nothing to compare it to. So even though the statute doesn't say that those elements exist, the courts have said they do exist, because without them, there's nothing to compare the speed that's codified in the law against to see whether or not the allegation is true and thus provable. So we have to, the complaint has to allege how fast they were going and what the posted speed limit is, so that we know how they violated either, or what they did that violated the other.
So the same in my case then with a headlamp. Even though it meant where it said headlamp, in general, in the statute, it only said lamps.
No, that's the improper way to word it. Where it meant headlamp infers that the legislature intended for it to say headlamp, but just messed it up. Mm-hmm. We're not making that argument. We're making the argument that the legislature knew exactly what it was doing when it said lamp rather than headlamp.
Okay.
The legislature did, but not the people who are interpreting the statute.
Right.
Yeah.
And so therefore, what were we trying to prove? That lamp was inoperable when in fact it was? Because the other lamps surrounding.
No, that's still the wrong way to word it. Think about how you're asking your questions. You had at least one lamp operating on either side of your car.
That's correct.
Okay. If nothing else, the driving lights were on.
Yes.
Unless the entire side, one side of the front of your car had zero illumination from any lamp whatsoever, you were not in violation of the statute.
And there was no offense codified in that statute anywhere.
That's also correct. There's nothing there that actually makes any of that an actual offense.
But if it did say headlight, what then?
Again, the statute.
It does say it does say what a headlamp is and how it has to be mounted. But it doesn't say that a headlamp is required. It simply says that the lamps must make objects visible at least 1,000 feet ahead. Mm-hmm. Or I'm sorry, makes your car visible from at least 1,000 feet ahead.
So does that mean, Eddie, then that the mounting?
That does not mean that your car has to illuminate up to 1,000 feet.
No, they just have to see
your
that the
car
lamps
must
are
be
mounted.
visible. That the lamps on your car must be visible from at least 1,000 feet.
Yeah, at least one of them was, and there was a headlight on the other side, so they can't say that.
Well, if the headlight was out, then every other lamp that would be lit on the front would still be visible. But because the headlight is the brightest spot, it obscures the others. But the fact that you could see the light from the headlamp at 1,000 feet or more means that your car was visible.
Yeah.
So therefore, there was no offense.
Right.
And therefore, the traffic stop was null and void and unlawful.
Yep.
All right. But anyway, back to what we're dealing with here.
Mm-hmm.
Now, let me get this other document up here real quick because I want to show y'all exactly how this is organized before we get it filled in so you can see what we're looking at.
And you're going to put this in the document itself?
Not until I'm finished with it. I'm not. No.
Okay.
I don't know. Okay. All right. Let's see, I should have two of these in here. If I don't, then that's going to be. I didn't make a separate copy of it before I started, so we'll just work with the one that I've got here. All right. But what you'll see, let me break this down for you here. All right. I know y'all can't see everything about how this is, but what I've done is I've got a section for each witness. Okay. Everybody can see the witness name up here. Animal Control Supervisor Lori Hullinger, interaction. Since Jane didn't have an interaction, she only is going to be called as a witness, presumably, either by Jane or by the city attorney. This is what we're going to do it. Now, Jane, if they never call Hullinger to the stand to testify, you don't need to call her.
I'm not going to. No.
Can I finish what I'm saying?
Go ahead.
You can get what you need about Hullinger from Delgado. Okay. But in the off chance they do call Hullinger because she's the supervisor of Delgado and everything, let's assume that that's true, and we're going to have to ask these questions. All right. So I highly recommend that you start off on the good side of things by paying the witness a compliment, or at least being congenial about them looking well today, or thank you for being here, or something of that nature. Okay. All right. I highly recommend you do that. You don't have to, but it sets a tone that hopefully you will maintain self-control enough to keep up appearances through the rest of your cross-examination. Got that part, Jane?
Yeah, I have issue with that, but I'll try to rein myself in.
All right, Supervisor Hullinger, you've been employed as the head supervisor over the City of Irving's Office of Animal Control for just over 5 years now, correct?
Yeah.
And you are the direct supervisor of that office and all of its personnel, correct?
Mm-hmm.
In a manner of speaking, that makes you the chief, like the chief of police over the Animal Control Office, correct?
Mm-hmm.
So then we could just make a rhetorical comment. It's not a question. So you are the top dog, so to speak. Now they can answer that or not answer that. Okay.
Mm-hmm.
Now, for the sake of time and brevity, would you mind if I shorten Animal Control Officer to ACO for the rest of my questions? Keep playing the part, Jane.
Okay. Oh, I didn't know I was.
You have been. You said boo to everything I said so far.
Sure.
Great. Now, Jane, at this point, you will point to any ACOs that are present and appearing as a witness and ask by name, or ask the Hulligan
Bollinger.
or Hullinger, whatever the hell her name is. ACO Delgado and any other officers that are present, and ACO so-and-so and ACO so-and-so, they are, or she is an ACO that you supervise and direct on a daily basis, correct?
Okay, yes.
And is part of your supervisory role over these ACOs to provide training and direction on how to do their job properly?
Yes, but they get trained elsewhere, but yeah.
Just answer the question.
Okay. Yes.
Is that training formal or informal? And by formal training, I mean, is the training provided by some third party or organization outside of the city and your department? And by informal, I mean, is all the training provided in-house by you or some other internal person or department of the city of Irving?
Both.
Which one is it?
Both.
It's both. Okay. Does any portion of your supervisory role include directing your ACOs on how to read, interpret, and apply any of the ordinances that your office is responsible for enforcing?
No.
No. Does that mean that your ACOs are required to just figure out on their own what the ordinance says and means?
Well, they can read English.
So they're not trained. Now, see, I don't have that question here, but we can address it. Then who do your ACOs go to when they have questions about an ordinance in order to understand and enforce it properly?
Me?
Okay. Well, it can't be both ways. You just said that part of your supervisory role is not to teach them how to properly read and apply an ordinance. And now you're saying that you're the one they come to with questions if it is?
Well, I'm saying that they do, and I answer the question.
Okay, so you are the one instructing them on how to read, interpret, and apply an ordinance.
No, I mean, they're responsible for reading the English language themselves.
That isn't the question I asked you. I asked you first if part of your role was to directing your ACOs on how to read, interpret, and apply any of the ordinances that your office is responsible for enforcing, and you testified no. Then I asked you, does that mean that they're required to figure it out themselves? And you said yes.
As the situation arises.
Let me finish asking my question. Then I asked you, who do your ACOs go to when they have questions about an ordinance in order to understand and enforce it properly? And you just testified that it was you. Do I have that testimony thus far accurate?
Sure.
Is that a yes or a no?
No, it's not, it doesn't work like that.
Okay. Then how does it work?
It's just like when they're, okay. We've had training on how to do our job.
Wait. Who did the training?
We have inner office training. We have like local training.
Who conducts that training?
I don't know. I have to look in her documents. But also outside training, we have training to how to do our job, like bite stick, investigating.
Well, I haven't asked you anything about any of that part of your job.
Well, as far as
stop and listen to the question. I specifically asked you about what your personnel does when they have a question about an ordinance. Who do they go to? And you said it was you, after first testifying that was not part of your responsibilities as their supervisor, and that you did not do that. So were you lying on the first question I asked you, or are you lying on the question now?
Actually, I don't know how she would answer this, Eddie.
Then why did you answer it all instead of just saying, I don't know?
Well, because I thought I was supposed to be playing the role as her. But
that's the thing, Jane. You would be playing the role just as her.
I know.
Because she would do either the same thing you just did, or she would say she don't know.
Okay.
What I'm trying to teach you is how to impeach a witness's credibility.
Okay.
Because it can't be the answer you gave to both of these questions.
All right.
One of those answers must be a lie because it's a contradiction of the other question and answer.
Mm-hmm.
Right?
Yes.
Then pound that dead horse just to make sure that that's on the record, which is what I'm doing.
Okay. I know that.
You don't know who they're supposed to ask if they have a question.
Actually, I don't know about the officers, but she has a legal advisor that works for the city that tells them certain things that they're supposed to contact to find out.
Again, then the answer would be from her what? If she has a legal advisor, she would answer, I refer them to so-and-so. Right?
Yeah. I mean, yeah. Well, no, she does. She contacts them herself. I don't think she has the officers do that. She's supposed to be the one asking the questions. And
Okay, then she is the one that then instructs the ACO.
Yeah.
Right?
Right. But, I don't think they do that, though. I think they just do what they want to do. And you already know they do. They think something is a violation and they just write it up.
Hang on just a second. Okay. All right. So ultimately, you are the person that conveys the information to your ACOs on how to read and enforce the ordinances that you're responsible for enforcing.
Mhm.
Correct?
Correct.
All right. So would it be fair to say that you are the person that all of your ACOs come to when they have a question about how to properly enforce the City of Irving ordinances governing their duties as ACOs?
Yes.
Do you attend any form of continuing education on how to properly supervise and manage a municipal animal control agency?
No.
How do you know that, Jane?
Well, I have all of her training information, but I don't think that.
How? Okay. And does it show that she did it all at once at the very beginning of starting the job, or does it show that she's done it over a period of time?
It's done over a period of time, but
okay, then it is continuing education.
Let me see here. I got it right here. Yeah, it's just like it's continuing education, but nothing like that kind of a subject matter.
You don't know that. You weren't there. You don't know what was in the training. You just know what the name of the fucking course is.
Okay.
Okay. So don't make assumptions. Make them testify on what the facts are. Don't assume anything.
Okay.
Okay. Now, if the answer is yes to that question on do you attend continuing education, great. How many times a year or how often are you required to attend such training? Jane, according to the record you have, how, over what span of time do they attend or get re-educated or attend a different set of training?
She hasn't had any training since 2023, according to this. But over a period from 6/22, 2020 through 11/15/2023.
You can just say from the time you started the job in 2020 until some point in 2023, you attended this course, and this course for a total of 3 different education sessions, right?
Yeah, but the the health and welfare statute, what is it called? It says they have to have training every year, but I don't see that. It's not in here now. See, I mean,
They have to have training every year. Where is that?
That's in the health and safety code is where I saw it. I have to find, I don't have it off the top of my head. I'll have to look and find it again.
Well, find it and print out a copy of it, and then make sure you tell me what it is, because that's going to be a very important exhibit in this cross-examining this witness.
Okay. All right. Let's see.
Do any of your questions address that statute?
No. I mean,
why? Why the fuck not?
Because I just now thought of it again. But the thing is let me
guess. Your questions also don't include any of the things I've asked thus far.
Yeah, I mean, I'm not asking the questions of. I have the 2 cross examinations for the witness, the neighbor, and the animal control officer. I haven't done.
That is not what I just asked you.
I just told you the 2 that I've done. I haven't done this one.
I don't give a shit. What I asked you was, Does any of your questions reflect the information I'm asking the witness about here? Because you would be asking similar questions of Delgado.
No, because I have those in another cross-examination, but you told me in the email that I needed to have all my questions related to the 3 elements, and that's what I did. Those other ones I have also that I can use as
Jane,
well.
knowledge of ordinance. That is one of the things I gave you. It just so happens that knowledge of ordinance has to come from what?
From
Either
training.
themselves or specific training, right?
Yeah.
So
Well,
the questions I'm asking under knowledge of the ordinance are geared at discovering how they got that knowledge.
that's not what the only thing you had in the document that you sent me just said questions related to health and safety, questions related to the public property damage.
That was the email I sent you.
Yeah, that's the only thing.
But I sent you a specific outline of it, just like what I started with to do what I'm doing now.
Oh, I didn't get that.
Yes, you did get that.
Okay. Well, I do have questions related to this, but only for the officer, not the supervisor yet. But now I know
All
what.
right, guys. Let me look at something real quick here. I want to see where the email is that I sent.
Good, because I don't recall.
I know you don't recall, Jane. That's your biggest problem, is that you
No, I
don't
read
recall
every
when you
email
need
you
to
send me.
recall.
No, I'm on top of every email you send me.
Really?
Yeah. Only you and the court most of the time are only 2 people who send me emails on that email.
Yeah, see, this right here is the email I sent you.
Let me see here. Back to one.
And I'll put it up here real quick so that everyone can see what was in
How
it.
long ago? Yeah, that's right. I didn't. Okay.
Okay. Can everybody see this?
Okay, I didn't see that bottom part. That wasn't on there.
No,
Oh my gosh.
this right here, Jane.
No,
This
yeah.
was the basic outline that I sent you to start with.
Yeah, that's exactly right. And that's
Okay.
what I made my question surrounding that right there.
Again, Jane, you have to go beyond just the things that I sent you in this regard, because that's not all the things you have to know. For God's sake.
I have the other things and other cross-examinations. I just don't have it combined with the ones that I did today because of that email.
In any case, this is why we're asking about their training.
Okay.
So let's continue.
All right.
Are the ACOs serving under you also required to attend training of any kind on how to properly perform their duties?
Sure. Yes.
Okay. Now, relative to their specific duties, are the ACOs serving under you required to attend training equal to the amount or type that you receive?
No. I don't know, actually. I don't know.
So do the ACOs serving under you receive less or different training?
Less.
Do you remember the approximate date of the last training that you received?
11/2023.
Okay. Now remember, this question would be asked only if they said no to 13. Okay. And if they say anything other than yes, like giving the date and everything like Jane just did, then you won't need to ask 14. But 14 is there in case they don't. Do you remember the approximate day of the last training that your ACOs received?
Oh, last training the ACOs received?
I'm sorry, never mind. That's a separate question. So they answered 13. They have to give you the date of the last training. You remember the date of the last training that your ACOs received?
Yes, the last for Delgado is on November 2024.
Okay. But the supervisor of Delgado hasn't taken training since 2023.
Right.
Okay. And you don't think that's useful information.
Yeah, it is.
Okay. Now, are you sure that the training is not specifically for the field officers rather than the supervisor? You need to read that statute again carefully and make sure you understand whether it's all of them or just the field officers.
I was trying to pull it up. Let me see here.
During any of this training that you and your ACOs have received, and I guess to your knowledge, and why do we have to ask to your knowledge?
She can only answer about her knowledge.
Correct. Were any of you ever specifically taught how to properly read and interpret a statute or ordinance?
I don't know.
You don't know.
No.
Now, if they say yes, then we ask this question. To the best of your knowledge, was the person doing that particular portion of the training a licensed attorney? We want to know who told them how to read and interpret a statute if it was not an attorney, or if it wasn't an attorney. Great. And just so I can understand your training background a little better, do you yourself have a law degree or have you attended any classes relating to law school?
Or the University of Missouri Law Enforcement, but it's nothing to do with interpreting ordinances. So no, I have a bunch of training, but nothing that is legal training. Okay, here it is right here. I found it. The training required. You can put it in the chat.
Yeah. The link to it, not the statute, the link to it. Do you yourself have a Juris Doctorate degree or have you attended any classes relating to getting a Juris Doctorate?
No.
Okay. Now, if the supervisor and ACOs do not receive actual training, just so I'm clear and for the record, neither you nor your ACOs have ever received any formal training through the city of Irving or any third-party individual or company relative to your respective positions or jobs. Correct?
Right.
Great. Have you actually read City of Irving's Code of Ordinance, Section 680 in its entirety?
Yes.
That would mean that you have direct personal knowledge of the ordinance's contents, correct?
Yes.
Why do we ask these two questions?
To make sure that they know what it says or that they've read it.
We get that from the questions themselves, Jane. Why is that important to do?
Because they need to know how to interpret or how to read them in order to do.
The fact that they read them doesn't tell us they can do any of those things.
Well, they have to know how to enforce it. If they don't know how to read, if they don't understand it, and they don't know how to enforce and do your job. Then.
Since when has that ever been a requirement? Where does their job description say they have to understand it in order to enforce it?
I don't know. I don't have the requirement.
Well, then you're making a supposition, and that makes your answer wrong.
All right.
Okay? So again, why do we need to ask these two questions? Think about the times you've watched a trial going on and someone asked a cop about a statute. What happens immediately when that occurs?
Prosecutor objects and says they don't have to know that.
Bingo! But if we just got them to testify that A, they have read it, and B, they think they understand it, the prosecutor can't fucking do that, can they?
No, but do you think the prosecutor is going to let them get that far?
The prosecutor has no choice. We haven't asked them what it means or what it says without first asking them if they have personal knowledge of it. And they can't stop us from asking if they have personal knowledge of it. Even if the prosecutor does jump up and say, objection, they're not required to know that, then you reply with, Judge, I didn't ask them anything about what they're required to know. I asked the witness if they did have personal knowledge. And that is a fair and relevant question. You got to remember, the prosecutor recognizes what you asked. And now they're going to play legal semantics by wording their objection the way they did. And if you don't know what they're trying to do, they will be sustained to get away with it. So have an answer and shut them down. Judge, I did not ask the witness a question based upon what they're required to know. I asked them specifically if they had personal knowledge, and they testified they did. Therefore, I have a right to ask them questions about what they know relative to their job in this case, or their job as it pertains to this case. You get it?
Yes.
Anybody have any questions, complaints, or addendums to what I just said, or think they know better?
Y'all should ask some questions.
I mean, I'd love if a real attorney was in here looking at this and going, yeah, this sucks, or no, it doesn't. All right. So we've made it where the attorney can't object to us asking the witness about their personal knowledge of the ordinance because we got them to admit they have it. Okay. So if they have to answer yes that they have direct personal knowledge, and then we do this because that is a yes to 18A. After reading section 680, 6-80, do you believe that you are fully aware of and understand everything written in it?
Yes.
They would kind of have to answer that way, wouldn't they?
I would think so.
Because what happens if they say no?
Then I would say, Your Honor, the person doesn't know how to read or how to interpret the ordinances she's hired to.
No, you would not say that if you're smart.
Well, what is that then?
Well, I'm waiting on somebody.
Yeah, somebody else answer, please.
Somebody think on your feet and give me an answer.
Sorry, I'm trying to feed cat too at the same time. There's a bunch of people in the class, aren't there?
Yeah, there are. If the witness, a professional, says that they don't know anything or understand anything about the statutes or ordinances they enforce, then they're admitting to be incompetent at their job. Are they not?
Yeah.
And they're admitting that they're enforcing an ordinance in they are potentially enforcing the ordinance in a manner that has nothing to do with what the ordinance says because they don't actually understand it and know what's in it. Now that's a hell of an admission, isn't it?
Yeah.
Okay. So if we get a yes to that question, then we ask this one. Great. Judge. Oh, and also there is a little bit of manipulation going on with the witness in the way we're asking these questions. What we're doing is we keep, every time we get an answer we like, we say great. Okay. Pick a term and use it repetitively to the witness because it gets them focusing on your use of that term rather than what you're actually asking them. Okay. So they're not as focused on what you're asking to the point that you may be able to lead them right down the rosy path to where you want them without any problems or any pushback. Judge, I would like the court to take judicial notice of City of Irving Code of Ordinances and its City of Irving Code of Civil and Criminal Ordinances, right? You'll pull whatever the full proper name of it is in here the first time you use it. And then you'll just say, Judge, can I please just refer to it as the Irving Code of Ordinances from here on?
Irving Code. I put that in the chat, that training requirement,
A link to it?
a link to it.
Okay. All right. Now, it's important that when you ask the court to take notice of an ordinance or a statute, this is what you do with it. Have at least 4 hard copies of the ordinance 6-80 in this case ready, and give them out as follows after getting permission from the judge following step B. This is how many copies you need and who they're for. 1 copy for yourself, 1 copy for opposing counsel, which in this case is the city attorney, 1 copy for the judge, and 1 copy for the witness.
Okay, now this is after we've already got part of that into the record, because here's the thing. I tried to do this in my speeding trial. I was not allowed to do this.
I guarantee you didn't, because you didn't set it up the way I've set it up to this point.
Well, I can't ask questions about things that have not already been testified to, right? Or brought up by the prosecutor.
Wait, say that again.
Hey, Eddie, I have a question. Oh, go ahead.
Go ahead. No, go ahead.
I have a question. Like, if she decides to do the four copies of the ordinance, does she need to have like the legislation? What is it called? Like the legislation intent, like at the bottom or something, for them to know it's the official ordinance? Like, would they object to like best evidence rule or something? Because or does that only apply for like a document? So my question
I'm
is,
not
like,
following you. Ask that again.
Like
okay,
a certified copy. Certified copy is what you're saying, right?
no. Like she's making 4 copies to each person, but how would they know that's the official ordinance?
Well, when we get to the next thing down, you'll see.
Oh, okay.
I remember the judge saying in that case that you can give I can take judicial notice of it, but you can't just give them copies of it or give the witness copies of it.
And what was the judge's rationale? I'm just curious.
I don't remember. I have to go back and listen to the trial. It's been a couple of years. But that's when I got thrown in jail, remember? That's the thing I remember mostly about the whole deal.
Hang on just a second. This thing's drawing on my damn screen here. Are y'all seeing the yellow lines on the screen?
No.
Oh,
Yeah, I thought I did it, but like, wait, that's not possible.
Well, somebody was doing it, because I'm pretty sure it wasn't me, because I don't have it enabled on my end, but it's popping up here anyway.
Well, I don't think anybody else can do it.
No.
Well, they're not supposed to be able to unless I set it up that way. But okay.
Yeah, how'd that happen?
And of course, the Zoom instructions are stupid because they don't. The menus look nothing like what they say it says. So I have to go in and disable it in the web portal. Hang on just a second. Web app. Whiteboards.
But I would have to get a certified copy of the ordinance, right?
Or you can get a copy of the Code of Ordinances from the city and take it in there as a hard copy provided by them. If they have it in a PDF online, then you can just print out the PDF and say, this is a PDF copy gotten from online from the city website. Do we agree?
That ain't gonna work.
I swear that damn Aussie's looking to get home. Ugh. All right. Try to ignore the damn yellow marks. I don't know why they got here, and the damn whiteboard will not clear from my end.
I can't see any white yellow marks.
Yeah, I can't see anything either. I don't know what you guys are talking about.
Well, my screen has them, and I don't know why they're there, but still.
I see it.
In any case, Judge, this is a copy of the City of Irving ordinances.
See, he's sitting there on a computer and he just pulls it up and looks at that. He's taking judicial notice of it.
All right, Judge, this is a PDF copy of the City of Irving ordinances obtained from the city's web portal, and it contains section 6-80. Provide a copy of hard copy of City of Irving ordinances, section 680 to the city attorney asking, do we agree on that? That's how you get them to agree to it. Okay.
Okay.
Judge, permission to approach and provide a copy to the court. And the judge, if they are on a computer like you're saying, will say, no, I have a copy up here, but go ahead and let me have a copy just so I can make sure it is the same as what's on the website. Okay.
Okay.
Now, be aware that a bailiff may come and take the copy and hand it to the judge for you, or if granted, approach the bench and hand the judge a copy of the ordinance. You see, I'm trying to idiot-proof this as much as possible.
Well, the bailiff will come get it, you know.
Judge, I ask that a copy of the ordinance also be given to the witness at this time. May I approach the witness and give him or her a copy? Again, bailiff may come and take it and give it to him if the judge allows it, or if granted, approach the witness and hand them a copy of the ordinance yourself.
Okay, what if he doesn't
If he doesn't what?
allow that the ordinance be in the hands of the witness?
Judge, I'm just asking them to have a copy in case they need to refresh their memory about what they personally understand it to say.
Okay.
They already testified that they do, but in case they need to refresh their memory, I would like them to have a copy so they can look at it. I have no objection to that. City attorney, do you have an objection to that? Never call the city attorney the prosecutor. Everybody understand that? Never fucking ever call the city attorney the prosecutor.
Okay.
Calling them the prosecutor makes them look legitimate, and they're not. They have no legitimate power to act as a prosecutor in any court in the state of Texas. Not when it comes to prosecuting in the name of the state. They have no legitimate authority. A statute under the Code of Criminal Procedure cannot give them that authority. And so we're going to file a motion challenging that also.
But an assistant district attorney could,
Or a county attorney could.
or a county attorney. Okay.
Okay. Now, we also want to know, have you also read City of Irving Code of Ordinances section 6-1, the general definitions section? And please, and we tell them, please feel free to look at the copy I provided to you to refresh your memory if need be, okay?
Okay.
Now, if they answer yes, that means you also have direct personal knowledge of the general definitions applicable to all City of Irving ordinances, correct?
Yes.
After reading section 6-1, do you believe that you are fully aware of and understand everything written in it?
I don't know.
Well, you testify that you understood the ordinance 6-80.
I understand how to read English.
Well, an ordinance isn't written in English. An ordinance is written in legalese. So please answer the question I asked you, which is, you testified that you understood section 6-80, correct?
Yes, I understand how to read it.
I didn't ask if you understand how to read it. I asked if you understood it.
I don't know how she's going to answer that.
Well, unless she wants to be called a liar, there's only one way she could answer it, right?
Yes, I guess yes. I understand it and how to read it.
Okay. Then in order to understand it, you must also understand 6-1, which provides definitions for terms that are used in 6-80, right?
Yes.
Okay. So we have now established personal knowledge of the witness to both ordinances. Nothing we ask the witness about the ordinance can be considered speculation or outside of scope of their personal knowledge. Right?
Right.
So now the only thing that the city attorney can reasonably object to is what? Or reasonably try and object to.
Badgering the witness.
We're not badgering anybody. We're asking a question.
Required to know.
Yeah,
Nope, not required to know either. We already know they're required to know, but what specifically is the objection the city attorney would have to try and use next, since they can no longer use the first one?
Relevance? Maybe not relevance. Can't say that. Let me see. Look at my objections. Cheat sheet.
Oh, excuse me for 1 second.
Anybody got any odd ideas? Y'all come on.
Applicability.
Well, that's the relevance, but that's not gonna, I don't think that's gonna be it. Improper lay opinion? No. Let's see here. Don't see anything. Speculation, maybe?
Okay, anybody come up with an answer?
Argumentative speculation.
Well, we know it's not speculation because they admitted to already knowing it. We know it's not argumentative because we didn't ask them anything that involves an argument. We asked what they know. They said they did know. So what does that leave the city attorney to try and object with to prevent us from getting our question in?
They may try to object and say she's not required to know it.
We've already established that we didn't ask if they were required to know it. We asked if they did, and they admitted they did. They testified they did. So the city attorney is attempting to suborn perjury by making them admit they lied.
Ask and answer.
No.
Best evidence rule.
We didn't ask a question that's already been asked, and we're not trying to get anything at this point admitted into evidence.
Yeah.
We haven't said a word about evidence, have we?
No.
Cumulative, repetitious.
Nothing about this is repetitious. It's logically going from one question to the next.
Argumentative.
It's on a paper, so it can't be hearsay.
Okay.
Well, I don't see any other.
The only other thing that the city attorney could try to do to argue against having them read the ordinance is say objection relevance.
Oh, I did say that, but I guess you didn't hear it. But to me, it is relevant.
It absolutely is relevant because it's a statute governing the charge. It contains the elements of the allegation. How can it be irrelevant?
Okay.
How could the definitions that control what the statute with the primary elements mean not also be relevant?
Correct.
Because the charging ordinance can't be the charging ordinance without the meaning of the terms it uses as defined by 6-1. Right?
Yes.
Learn to connect the dots, people. Now, when was the last time you actually reread ordinance section 6-1 and 680?
Okay.
How's that an okay response?
I said today.
Today. You reread it today before you came to trial
Yes.
to give this testimony.
Yes.
So you are absolutely refreshed and familiar with what it says.
Yes.
And therefore, and you believe for certainty that you understand what it says and what it means.
Yes.
Okay, great. based upon your personal knowledge of Ordinance Section 6-1 and 680, would it be fair to say that you enforce Section 6-80 based entirely upon what you personally believe it says?
Yes.
Great. Now, if you would please, based upon your personal knowledge and using your own words, tell us what you believe Section 6-80 actually prohibits, specifically regarding the feeding of animals.
It prohibits feeding of animals that creates a danger to public health and safety, that destroys.
Wait a minute. Are you sure that's what they're going to say?
Well, if she's familiar with
Think about what the animal control officer has said and what she instructed the animal control officer to do.
the feeding animals outside is causes a danger to public health and safety.
No. Again, that's close. That's almost right. Okay.
Yeah.
But if she'll either say that, or she will say that feeding animals outdoors is illegal, which is exactly what the complaint is trying to say.
Right.
Okay. And I haven't got all of these questions ironed out yet because I want to ask specifically about the complaint as far as that goes. But anything that they're attempting to avoid answering is already specified in the complaint. And since they're the alleged complainant, they have to have personal knowledge of what's in the complaint too, right?
Right.
Okay. So, oh, and by the way, you are going to ask the court to read the complaint. Do not waive the reading of the complaint.
Yeah,
Make sure they read the complaint in its entirety into the record.
that's fine.
Okay.
You can't object while they're reading it either, can you? Because I did that in the first.
Don't. You
Okay.
wait till they finish.
Okay.
And then you can say, Judge, I would like to remind the court that I filed a written objection to this complaint and the way that it's worded and written, or the way that it's worded, and that it's non-specific in a motion to quash or set aside long before this trial ever began.
Okay.
Yeah, and I did the same.
Okay.
Yeah.
And make sure you say that for the record. I filed a written motion to quash or set aside for the legal insufficiency and deficiencies that are in that complaint long before this was even scheduled for trial. That motion never got heard by this court. That motion was never ruled on by this court. This court just let it expire due to time and therefore be automatically denied without any cause or basis.
Well, that's changed now, so I just filed the last motion today, and I didn't schedule for a hearing, which I should have done, which I can still go back tomorrow and do.
Okay. In any case.
Okay. But it'll be denied.
Okay. All right. Next question. Are you certain that your reading and understanding of the text of section 6-80 of the ordinance is legally accurate relative to the specific activity it prohibits?
Yes.
Okay. If they say yes to A, could you please tell us what specific activity you believe is expressly prohibited by the text of section 6-80A of the ordinance?
6.80A. You mean E?
No, A.
Where the hell is A?
It's above E.
Okay, well, I don't have it in my printout that I have. Let's see here. Is it the one that says a person is deemed to have fed? If he or she places it.
Is it labeled A?
No, I don't. I have it. I print out. I have it copied, but I don't see the A in there.
I swear.
Oh yeah, here's A. It's a defense to prosecution. A. No, I don't have A on here.
Of course you don't. That would be useful.
I don't know where it went, but I have E.
All right, where in the
1,
hell?
2, 3. And then,
I don't know.
is it the owner of any animal in the city is responsible for the
Yes. Doesn't it have an A there?
No, but I can put one there. I didn't get that part copied over, I guess. Okay. Okay. All right. So I'm supposed to, the owner of any animal in the city is responsible for the behavior and conduct of any animal at all times, including conduct that constitutes a public nuisance. And a person who commits an offense, if by act.
Okay. I'm sorry. I am also incorrect. Let me get this up here. It
You're killing me. Okay.
the A is not above this, which it normally would be. That's how ordinances would be written. I don't know why they do it this way in the city, or I'm sorry, how statutes would be written. So the general part of 6-80 reads, the owner of any animal in the city is responsible for the behavior and conduct of that animal at all times, including conduct that creates a public nuisance. A person commits an offense if by act, omission, or possession, he or she allows an animal to create a public nuisance. The following are public nuisances. Okay.
Mhm.
Now, they're not charging her with animals at large.
Thank God.
Okay. In any way, shape, or form.
That'll be next time.
All right. So A is inapplicable here. They specifically charged her under Section E. The problem is they charged her with three completely different possible crimes or offenses under subsection E, which is why the complaint's invalid, because it doesn't provide any specific charge to make her aware of which one she has to defend against.
But even when they corrected it, you said, that doesn't
They
work.
still didn't put any details about how she committed any one of them.
Right.
Okay. So you were correct as to the original number, Jane. Yes, it is specifically 680E itself, not E1, E2, or E3.
And in case anybody else doesn't know, the prosecutor did respond to our motion twice. She responded.
Yeah.
I don't know if anybody knows that or not.
I'll be surprised if she responds a third time, but let's see.
Oh, she won't.
All right. Oh,
He's tired of it already.
we'll see. All right. Anyway, the ordinance says a person commits an offense rather than an offense if he or she intentionally feeds any animal or makes available for animal consumption in a manner that. Okay. So the feeding itself is not prohibited conduct. The prohibited conduct is feeding in a manner that does one of these three things. Everybody clear on that?
Yes.
Gotcha. Well, to the prosecutor or whoever's charging document is, yeah, that's a gotcha just by reading that.
Yeah, it is. It is. But I finally had it drilled into my
Okay.
head.
However, the complaint, yeah, it took quite some drilling too. I wore out four oil bits trying to get there. All right. Now, let's see. This is the actual original complaint. That was filed. Okay. Now notice the complaint says, I, the undersigned affiant, do solemnly swear that I have good reason to believe and do believe that based upon a report to me by Natalie Grimaldo Delgado, animal control officer, who observed or investigated that Jane Gray Lynch on or about the 10th day of March 2025 and before the making and filing of this complaint within the territorial limits of the city of Irving in Dallas County, Texas, did intentionally feed an animal or made food available for animal consumption in a manner that creates a danger to public health or safety, destroys public or private property, or causes 11 or more adult animals to congregate in one location at the same time in violation of Section 6-80E, City of Irving Code of Criminal and Civil Ordinances. Okay? But remember, the ordinance specifically says that you must intentionally feed, and he or she, the person here, must be what?
An owner.
The owner of the animal. It can't be just somebody feeding an animal. It has to be the owner of the animal. So somebody's going to have to get on that stand and testify that Jane is the owner.
Well,
And they're going to have personal knowledge that that statement is true.
not just me saying it out there the day when they on the body cam.
Did you say you own them, or did you just say my animals?
I said, well, I feed my 2 cats on my front porch.
Okay. My 2 cats does not say the same thing as the 2 cats I own. Does it?
No.
It could just be my 2 cats in reference of the 2 cats that I take care of by feeding them that show up here or whatever. That could be true also from that statement, right?
Mm-hmm.
So inferring or believing or presuming that your cats is the same as cats I own isn't necessarily legally accurate, is it?
No, I'm just like term of endearment or something like that.
Exactly.
Yeah.
Okay. So the owner must intentionally feed the animal in a manner that, and it doesn't say might create or could create. Creates means did create.
Right.
Right?
Yep.
Okay. So that did create a danger to public health or safety. Or alternatively, did destroy public or private property. Or alternatively, caused more than 10 adult animals to congregate in one location at the same time, which is where the 11 or more came from.
Mm-hmm.
Because 11 or more is more than 10, right?
Mm-hmm.
So that's the ordinance that she's being charged under. Everybody clear on that? And all the complaint did was mirror that language in the complaint without providing any specific details as to how she violated any one of those 3 possible offenses.
But they changed it and eliminated everything except for danger to public safety. But now
they took all of this right here out of the first amended complaint. They filed an original. This is the original. Okay. Then they filed this one, which took out those 2 extra charges in E2 and E3 and left just E1. Okay.
Mm-hmm.
But then they filed a 3rd complaint, which is the second amended complaint.
After our motion.
And they made it look exactly like what the first complaint did.
No. Matter of fact, it says Natalie. Is that Natalie Grimaldo, I wonder? Surely not.
Yeah, now it's supposed to be Natalie, I'm sure, not Nathalie.
She's not a deputy clerk, though.
Well, that's
I'm
not
an
her
idiot,
signature
and
at
this is
deputy
like-
clerk.
What was that? Somebody say something?
I said
Yeah, I
that's
said
not.
I'm an idiot. Oh, sorry. Go ahead, sir.
No, I said that's not her name down there over deputy clerk.
Okay.
Now, what were you going to say, sir?
I said I'm an idiot, and I know that there's a bunch of holes in this, and I'm not like full of knowledge of what's going on, but I get a picture, and whoever this cop is a dumbass.
Well, they
Because they make charges and they can't prove it.
Well,
Yeah.
the prosecutor's the one that wrote this complaint, I guarantee you.
Well,
Not the officer and
They-
not the clerk. or the city attorney wrote the one that the city clerk did themselves.
Yeah.
Basically, what you're telling me then is that in my case as well, the original complaint was created by the city attorney and not by the police officer himself, because he wouldn't have
Well,
had
no,
knowledge of the statute.
the officer
Uh-huh.
nor the clerk are ever the ones that writes the complaint.
Right.
They're just the one that attests to what's in it.
Right.
Software.
Right. And yeah, like you said, they used the software and they
use
mirrored the information that came out of the Texas municipal court.
the citation.
Yeah, their website, out of their citations that they use, which is under a general thing that they use, that mirrors the statutes, but that is all it does. And I even objected, like when I was doing the pretrial, I explained to them that all they did was mirror what was in the statute, but they did not express all the elements in which I was in violation of. But of course, you know that the assistant district attorney, of course, as a prosecutor, was going to argue that that complaint was sufficient on its face, and it was no way, shape, or form even near sufficient, nor was it properly sworn.
Yeah. All right. Now, does everybody see where I've got this highlighted up here, this blue box?
Yep.
Everybody see that date of 4/21/25?
Yes.
This is the original complaint, the very first one filed that we challenged. Okay. The date says it was filed on 4/21/25. This is the amended complaint, but it also says it was filed on 4/21/25.
Yep. It's a status date, actually, but.
And that's a BS response there. That was just a copy paste.
Yeah.
Well, let's look. Sworn to before me on the 2nd day of April 2025. Sworn to before me on the 12th day of May 2025. And then sworn to before me on the 1st day of July 2025.
Right.
Okay. So this is how we know for sure there are 3 different complaints, right?
Yes.
All right. So this is what I was going to caution you about. Don't look at this number up here, and because they're the same, but we know they're supposed to be different, that's the issue. It's not. You verify when it was sworn to. If all of these had the same sworn to before me date and statement,
Would be invalid.
now we've got a fucking problem.
Yeah.
Okay?
It seems to me like I've seen somewhere where they can't amend the complaint.
No, they can always amend the complaint up to the day of trial.
Mhm.
What they can't do is amend the complaint after trial has commenced.
Okay.
After commencement is perjury.
No, after the commencement, they have to dismiss the case. And if it's already commenced, jeopardy is attached. If jeopardy is attached, it becomes double jeopardy to stop it and start it again.
Well, they amended the complaint before on the
The
day.
only way they could stop it and do it again is for the judge to declare a mistrial. And the judge would not have grounds to declare a mistrial if all that happened was the state fucked up the complaint. All right. So once again, could you please tell us what specific activity you believe is expressly prohibited by the text of Section 680E of the ordinance?
Leaving food out for animals.
Okay, putting out food for animals. Okay. Judge, at this time, I would like to ask the witness to read only Section 6-80E.
The person commits an offense if he or she intentionally feeds any animal or makes food available for animal consumption in a manner that creates a danger to public health.
Whoa, stop. In a manner that. Okay. That means that what follows must have happened, right?
Yes.
Objection. She doesn't have to know that, requires a legal conclusion, blah, blah, blah. Judge, the witness already testified that they knew the language and understood it completely.
What if they did testify that they didn't understand it completely?
Then we move to dismiss because obviously, or we've proven that the witness's testimony can't be trusted. So now we have to disqualify them. Judge, the witness testified they do not know or understand the statute in question. Therefore, there's no way they could possibly testify as to its enforcement. If they don't know or understand it, there's no way for them to understand how to enforce it. Therefore, any testimony they provide is going to be strictly guesswork on their part, not personal knowledge. Now, let them go ahead and let the witness continue to testify after we get that in the record.
All right.
So hence the peace officer himself in my situation, he doesn't have the ability to really interpret what's in that statute.
No, he can't. He can do it based upon what he thinks or believes, but he can't do it as a legal requisite. He has no authority to make a legal conclusion.
So then that would be my argument.
Not if you're going to get him to testify that he knows the statute.
So first, that's what we need him to.
If you're going to get the statute introduced, yeah, you could ask the court to take judicial notice of it, but you don't get to pick it apart unless you get to talk about it. And you can't talk about it until you get the cop or the witness to testify that they've read it and they understand it. And that's what they're basing their allegation on.
Right.
But how you get, okay, you already showed us how to get there, but I just wonder how I'm going to get there with the prosecutor objecting, you know.
Well, I've told you how to respond to their objections, Jane.
Okay. All right.
Every single step I've shown you how to respond to their objections.
Okay.
Okay, now we ask the court to take judicial notice. And we've asked them if they know and understand it.
And you already asked about how much
All right.
left in the record.
All right, hang on just a second. I'm trying to.
Yeah, I wouldn't.
Stop talking.
What? What are you talking to me?
It doesn't matter. You're distracting me, and I'm trying to get my brain right back around the thought I just had on what we asked down here.
Okay.
Okay. All right, now I got it. All right. All right. There we go. And it is section 6-80E that defendant is being charged under in the complaint. And it is section 680-E that you are charging the defendant with violating in the criminal complaint, correct?
Yes.
All right. Now, you know what this also allows us to do?
Disprove their allegations.
It lets us use the complaint.
Oh. Why wouldn't we be able to use the complaint anyway? It was read into the record at the beginning of the trial.
You could, but what are you going to lay the foundation on to use it if you don't do it this way?
Well, to use it is because the prosecutor already read it into the record.
You're not you're missing my point. You haven't asked a single question about the complaint at all up to any other point in what we've done. So
Okay.
how would you use it? It's not been introduced except as being read into the record at the beginning of the trial. The prosecutor didn't ask anything about the complaint. They're not going to ask anything about the complaint. They don't want the complaint admitted into the record beyond the reading of it, which is why we had them read it in the first place. But how do we get to the point where we ask the witness on the stand about what's in the complaint? Since they're the one making the allegation and the complaint is based upon what they're alleging, right?
Yeah. You ask them if they've read the complaint.
No, we don't ask them if they've read the complaint. God damn. We ask them if the offense they're being charged with is the same as the one that's in the complaint. And if they say yes, then they've linked their testimony to the complaint.
What if they say no?
Well, now we've got a whole nother problem, don't we? So you're saying you're charging the defendant with an offense other than the one that's listed in the complaint?
I didn't read the complaint. I read the citation.
They read the complaint at the start of the trial. You were present for that, correct?
No, we're not. They're not in there until they come out and do their testimony, and then they leave.
No, they are in there unless one of the parties specifically asked for them to be excluded from the courtroom during the other witness's testimony. I guarantee you they are.
Let me think. Okay, the officer in the speeding trial, he was there the whole time. But the when I was in Irving court before for the trap case, they were not in there until they were to testify, and then they left after they finished testimony.
So they never entered the courtroom at all until they were called as a witness. You're 100% positive of that.
Well, at first, everybody was called at the same time to do their swear, and then they were excused until they were called back in.
And do they read the complaint before or after that?
They read the complaint at the very begining, and that
before they called them in to swear in, or before they swore them in, or after they swore them in and they left.
It was before they. Let's see what they. I can't remember. I'll have to go back and look. But I know that the neighbor, she was never ever there until she came in. They swore in just like the officer, and then they left. And I think none of them heard the reading of the complaint.
You think, but you don't know.
Well, I have to go back and listen to it. I don't remember, but I know.
Again, that just proves my point. If they were not in there to read the complaint, then we have to ask them, is this the section that you are charging them under as alleged in the complaint?
Yes.
Okay. Now, once they've said that, we're good to go. Okay. All right. Great. Now, if you would, please, based upon your personal knowledge and using your own words, tell us what you believe Section 6-80 actually prohibits specifically regarding the feeding of animals. And you testified that they can't do it in a manner that does blah, blah, blah. But manner is used in conjunction with that does create something, right? Not
Right.
could or might, but does.
Right.
All right. And are you certain that your reading and understanding of the text of Section 6-80 of the ordinance is legally accurate relative to the specific activity you say it prohibits?
Objection, Your Honor. The witness does not have to know that.
The witness testified that they did know and understand that, Judge, and I would like them to answer.
When you added legally and all that kind of stuff, I'm saying that I read and understood it. Yes. What it said. Yes.
I'm asking if you are certain that your reading and understanding of section 6-80 of the ordinance is legally accurate.
I'm saying I don't know if it is or not.
Then how can you say that you know and understand it?
I don't know if
It's a catch-22 question, Jane. That's the point. They cannot testify that they know and understand it and then say they don't know if they understand it from a legal perspective.
Why? I mean, why wouldn't they? Why would they put themselves out there like that and say that they understand it from a legal perspective?
Jane, again.
They're not the one that's charging me with this.
Jane, yes, they are, Jane.
Well,
You are still missing the whole point.
okay, I know. Okay, I know. You're just trying to get me to think outside the box or whatever.
No, I'm trying to think you in a manner that keeps them in a box. The whole idea is to trap them into something they cannot extricate themselves from. Okay? And prevents them from proving their case.
Well, remember,
if the witness testifies that they know and understand something, right?
Right.
And that something happens to be an ordinance, and they clearly testified they know exactly what it means and how it applies, right?
Okay.
And they cannot say that they do not understand it from a legal perspective because it is supposedly a law, right?
Their interpretation of what it is, it not necessarily meaning it's legal.
That's why we ask them, are you certain that your reading and understanding of the text is legally accurate relative to the specific activity you think it prohibits?
I don't know.
You don't know. Okay. So you don't know if what you know and understand about the ordinance is actually legally accurate. Just to be clear, that's what you're testifying to.
Yes.
Okay. So you are enforcing it based entirely upon your personal interpretation and beliefs, right?
Yes.
And your own opinion.
Yes.
Right. But not actual knowledge and understanding.
Right.
Okay. Are you also certain that your reading and understanding of the text of section 6-80E is legally accurate relative to the specific offenses that must result from that alleged prohibited activity?
I don't know.
So again, you're testifying only on what you believe, not upon what you know to be true, and you're enforcing the statute based upon what you believe instead of what you know it says and personal knowledge, right?
It's how I interpret it.
How you interpret it, okay? Now, I haven't got to these questions yet because I was doing all of it for that witness and then also applying it to the other animal control officer, Delgado. So there will be specific questions here that tears apart each portion of 680-E. Okay? We will go into it specifically to ask questions about, did you see this? Did this happen? Did you see this? And did this happen? If none of these things happened, then how is this charge satisfied?
Right.
What evidence do you have that proves this actually happened when you just testified none of it did? All they've got left is their opinion, and they can't offer their opinion. They're not an expert witness. At least not as to the truth of the matter. We can ask them their opinion about what they think or believe, but we cannot get them to testify that their opinion is fact on what the ordinance says specifically and requires specifically.
Well, I've got like 6 or 8 questions for each element.
Well, again, we'll see if they match up with the ones I come up with, okay? But they should be pretty similar to the ones we've used in past classes. Right?
Similar.
All right. I never did get an answer to my question for the class members. Would any of you have an objection if for the rest of this month we kept this class free and open so everybody that's here tonight and anybody else that can get to join comes in and goes through this to the end until the very last class of this month, when we will do a run through of the script in its entirety when we get it done?
I think that's a great idea.
I don't have an objection.
That way,
love that.
everybody can play a role because they've got a script to follow.
Hell, even after that, we could take that script and turn it around and fix my thing. That would be awesome.
You got a court. You got a well. That's just
Yeah, because on the 28th, we're setting up, I guess, when I should be sent to trial. So might as well go ahead and prep my ass now.
it's just it's an announcement for trial. That's right.
Well, an announcement for trial is when both parties say they're ready for trial. It's not that trial is going to happen.
No, it won't happen that day. He's going to announce.
No,
it.
No, I know
it's not going to happen.
What I'm saying is that both parties are supposed to announce ready for trial. And if
Yeah.
one party doesn't, they're going to have to give a justification on why they're not ready for trial. And then the judge has to say, okay, that's a good enough reason. We'll give you X number of days to get that completion, and then we'll come back and do this again and set a date.
Mm.
Okay?
Yeah.
So understand that process. That's what it is.
Okay.
All right. Any questions, queries, comments, bitches, moans, groans, complaints, or input before I get us off of here for tonight?
So for the trial then, what would be good excuses not to be ready?
Well, if you're looking for legal counsel and haven't found an attorney willing to take the case yet, that would be a reason. If you've put in for discovery and the state hasn't given what you've requested in discovery, then you don't have what you need to go to trial to prove your innocence or to refute their evidence, and you need the judge to compel them to produce it. Things of that nature.
What about if she's out of the country?
Well, then she can make the court aware of that if she hasn't already, that she's got
I
a
have.
non-refundable thing scheduled for a certain date and time, and that she would ask the court to be accommodating to that because it would cost her X number of dollars that she can't get refunded if she has to be here for trial and can't go.
Okay, I sent you that deal in the chat, and I'll send you these questions I came up with because I didn't get to read any of them. So, and they're good
Well, again,
questions.
I wasn't going to ask you to read them. I wanted you to compare yours to mine when we're done. And for the ones you've got that I don't have yet, just keep that in mind. All right. Nothing else then? Nobody's got anything? No questions?
Nobody's
I got a question.
Common? Okay.
All right, so the head animal control officer, they're not an expert witness, because if they're training people and they're giving
They're not an
information,
expert witness on the statute or the ordinance.
okay, but
They may be an
city-
expert witness on the process and procedures at the animal control office and how to do their job, but they are not an expert witness on the ordinance.
okay, so the city attorney wouldn't bring them in as one then.
No.
no, they're not.
For the same reason, a cop that's given testimony in a traffic case is never sworn in as an expert witness, and he couldn't be, because an expert witness is allowed to give testimony that is based upon opinion,
Yeah,
not just personal knowledge that this actually did happen.
and that's the whole
They
problem.
can offer an opinion that this could have happened because, and probably did happen because. That's an opinion. That's not a fact, but only an expert witness can do it.
And
Okay,
see,
gotcha.
and none of their training includes any kind of legal interpretation of the statute. It's all about
Well, again, you've got to get them to testify to that on the stand, Jane. You don't get to presume anything. That's why we ask these questions. We want to set them up for failure by getting them to admit that they read the statute, they think they understand it, but that they really don't.
Eddie,
Yes.
so I remember that you are yet a thing about the cop cannot uh, enforce the Texas Connotation Code.
Correct. But that's a separate issue.
But how will you make the argument?
You would make it by showing how the law requires him to be certified in a specific way by a specific entity. And if he admits on the stand that he doesn't have those certifications and training, then we've got evidence in the record that shows he was never qualified to enforce the transportation code to begin with.
What part in the Texas Administrative Code does it say that?
Rule 4.13C
Okay, thank you.
and Chapter 644 of the Transportation Code.
Thank you.
And I brought that up too at the beginning of that first trial. I brought it up and it was all overruled.
Kevin, did you get a speeding ticket?
No, I did not.
Okay.
I'm 14.
His dad has tickets, but he doesn't.
Okay.
I had a question.
Okay.
So I might have misunderstood here. Her,
You don't sound like Robert.
It says Rebecca.
Oh, I'm sorry. It's highlighting Robert's name.
oh, really?
Yeah.
Interesting. I just want to make sure I understood this. There was a element that was missing on her charges.
No, there's factual details that are missing in support of the elements of her charges. All
Okay.
the elements are there except for the specific factual details that support an actual offense consistent with those elements.
Which they say
Gotcha.
they don't have to have. They say they don't have to have, but they're wrong.
Right. Well, I was just wanting a clarification. I actually just went through this myself, and won my case as a pro se up here in Indiana.
Animal control case?
No, it was a disorderly conduct case that I was charged with that resulted from a traffic stop, and they were missing an element that it had to be done in public. Because in order to charge somebody under the disorderly conduct statute up here, you had to have disturbed somebody in the public, and that was non-existent.
Right. The officer can't be the complaining party in a public disorderly conduct case.
Correct, and that's the issues that I raised in mine, and the prosecution was not letting up on it either, so I filed a motion to dismiss, and thankfully the judge ended up granting it, so I'm getting ready to file for malicious prosecution.
I sent you that motion that she's talking about because I got that from Legal Society, the one from Indiana. I sent you that motion.
Yep.
Yeah. Cool. Well, yeah. So, like, I've been arguing with Eddie about the fact that they're trying to charge me for a public nuisance on private property, but he's not letting me address that. So,
Well, because really,
I
you
didn't
gotta.
say you couldn't address it, Jane. I said that that's not really the primary issue.
Yeah, you got to stay with your the focus
Okay.
of the charges.
There's nothing in the ordinance that deals with public nuisance.
except for the very top where it says public
No,
nuisance.
it says creates a public nuisance, but then it says these are the things that are considered public nuisances.
Yeah,
So
but
those are the things you have to address,
but
not the general thing of this is what we want to call a public nuisance.
okay, but my argument is that the Texas has already defined what public nuisances are, and so they can't redefine what the Texas legislation.
They can do whatever they want unless they're basing it on a state law, Jane. Then they're stuck with what the state law says. So unless you can show where the ordinance they're attempting to use is itself based upon an actual state law,
are you
rather than completely enacted by the city, that's why the argument doesn't fly.
Well,
That's the entire reason we made the argument that the ordinance cannot be applied to you on your private property. because there is no state law behind it that affects you on your private property. It's the same argument made a different way that prevents them from arguing that the ordinance doesn't have to worry about that. That's the part you keep not understanding. I am making that argument, just not the way you want to make it. Why? Because there is nothing in the ordinance that shows it is based on a state law that you can make that claim tied to.
Okay, so I guess the understanding that I'm having as far as what the Constitution says and what the statutes say, and
does the Constitution define a public nuisance?
No, the Constitution says that it can't be redefined, something that the legislature or the state law has already defined. They can't just come up with something.
Stop.
Okay.
Article 11, Section 5A specifically says that no charter or ordinance can do anything that's in violation of any provision of this Constitution or any state law.
And that's not the only place it talks about that. There's other statutes.
Stop.
Okay.
There are no other statutes in the Constitution.
They're outside the Constitution in the Code of Criminal Procedure.
Again, you first have to show that they base the ordinance on a state statute before that would apply.
Well, I didn't know they had to reference a statute for them to.
If they're going to try and enforce it against the public and on private persons and property, there has to be a state law behind it, because the city cannot create binding public law itself. It has to adopt an existing state law and base their ordinance on that state law. If that is not the case, then they made an internal rule that doesn't mean jack shit to anybody except its officers, employees, contractors, and people, and certain types of legal entities they're given permission to regulate within their jurisdiction, or somebody stupid enough to consent and allow it to have authority over them and their property.
And that's exactly what they've done in this situation. Yeah.
No, that's something you would have had to have done.
No, I'm not talking about that last thing that you said. I'm saying by them creating their own idea of what a public nuisance is.
They've limited who it can apply to.
Yeah.
Because it's not a state law or based on a state law, so they're stuck with it being something that regulates only them and those they can directly control.
And they can't control me.
Correct. You're not within their jurisdiction as an employee, a contractor, a legal entity, or someone who gave your consent. That's exactly what we said in the motion to set aside, quash or set aside.
I know. That's going to be really hard to.
Well, that's why we said it.
I know.
Now, did this part of the conversation lose anybody?
No, that last bit hit home because you're talking about in public policy, ordinance only applies to those in the public.
Well, what is a code of ordinances? What is a code of ordinances?
Not in the public. It only applies.
No, Jane, stop. I didn't ask where it applied. I asked, what is it?
I'm talking about what they just said. What are you saying? What are ordinances?
What is a code of ordinances?
Policies for a corporation.
Policies for the political subdivision that is operating as what? A public corporation. Not a publicly traded corporation or a publicly shared corporation. It is a public corporation. In other words, i.e., it's founded on the authority of the public to act as a governmental entity or sub-entity. That's what a public corporation is. Okay? That's the type of corporation our public entities must form in order to conduct business with other corporations and people.
Okay, but why have I know what you're saying. I agree with you 100%. I'm thinking about it from trying to look at it from somebody else's perspective.
Well, if I could finish the thought before we go running down your tangent road, because you never let me finish what I'm talking about.
Okay, go ahead. Go ahead.
Okay. Because they are a public corporation, and they created this set of ordinances. What does that make those ordinances? The policy of that corporation, the public policy of that corporation, right?
Yes.
Okay. So upon whom is the corporation's policy binding?
On those people that work for the corporation.
All of its officers and employees, right? All of the entities or persons who contract with them, because that will be a part of the contract that the vendor agrees to be bound by the ordinances of the corporation, by certain legal entities that they have authority to regulate within their territorial jurisdiction by law, because the legislature said they could, which is what by law means, or some moron who said, oh, sure, you can tell me what I can and can't do on my own property, or can or can't not do myself, and agreed to be bound.
Which 98% of people do that.
Well, that ain't your problem, is it?
No.
Okay.
So why would it be that they would put this corporation here to try to why would they put it in place if it's not binding on the people who live in their jurisdiction?
Fraud.
You already have that answer, Jane. I just told you it's to regulate the entity itself.
Yeah, but it's okay.
The fact that every corporation tries to flex its policies outside of its legal jurisdiction. Take, for instance, Peloton. When Peloton tried to sanction somebody to get them to remove support for John F. Kennedy Jr. as the Secretary of Health. Okay? And Dana White of the UFC heard about that and was interviewed about that on, I think it was Joe Rogan or some other podcast, and said, Peloton tried to get somebody to drop this because it wasn't consistent with their corporate policy. And he turned around and looked at his manager and says, is that Peloton's, those exercise bikes we have in the gym? Yeah. Oh, then get rid of them. As of today, Peloton will no longer exist in our gyms.
Right.
And he stopped doing business with Peloton because he's not bound by their policy. And he doesn't agree to be bound by their policy. And he doesn't agree with anybody else who's going to allow themselves to be bound by their policy that isn't actually a part of Peloton.
But we voted these people, like a judge or whatever. They were appointed by.
No, you didn't vote that municipal judge in there. Nobody voted that fucking judge in there. He was appointed by the city, hired and put in place by the city manager, just like the city attorney was. None of these people are fucking elected, not even the city manager himself. The only elected officials in the city are the mayor and the members of the city council.
Okay.
Every other position is appointed by one or more of those people, either appointed by and then approved of, or appointed by and approved of jointly by multiple parties. None of them are elected except for those specific individuals, the mayor and the members of the city council.
Okay.
Not even the police chief, the fire chief, the police commissioner. None of those people are elected. The only one elected in that regard is the county sheriff. But none of his deputies get the job by being elected, right? The only other one would be who? The county constable. They're elected.
But
because they're separate from the sheriff's department.
Yeah, but not any municipal court officers are
elected. Not a single one of them. The only time that is incorrect is if the county or district attorney is prosecuting the case in the municipal court. And Chapter 45A says they can't. And that right there is exactly why the city attorney can't.
Wait a minute. Not the county, since we don't have one in Dallas County, but we have a district attorney, and the district attorney could prosecute a case in municipal court.
Not if you read 45A. There's only one exception for when the district or county attorney can prosecute in the municipal courts.
And when
45A.005 specifically says that the city attorney shall prosecute all cases in the municipal court.
it does say that, but the Constitution says otherwise.
That's right, which is why we are filing a motion to disqualify the city attorney and get the case dismissed for failure to prosecute.
But I didn't know that 45A had changed to where it says that district attorney.
45.201 said exactly the same fucking thing as far as the city attorney goes. And 45 also contained the same exception.
Okay. Oh, you saw how they took out the Code of Criminal Procedure 2, the one that I sent you that other day about what to do when they get a complaint.
I answered the email back to you and saying it was repealed and it's been replaced by 45A.
And 45A, is it say anything different or better? I didn't look at that.
It says the same thing a different way.
Okay. Of course, it says it a different way.
But the gist of it is it means exactly the same thing it said before and it was still unconstitutional then.
Okay.
And remains unconstitutional now.